alleging that you've been held in contempt for flagrant disregard of a court order. The legal team of which you are part, to be specific, I think the combination of your lack of experience and that weighs heavily against your nomination.
Welcome back to Freedom Forge, your home for real talk, facts, and unwavering American values. If you're looking for honest analysis and the truth the mainstream won't tell you, you're in the right place. Don't forget to hit that like button and subscribe so you don't miss any of our deep dives into the issues that matter most to our republic. Today, we're reacting to a Senate judicial confirmation hearing. What's happening here is something every American should pay attention to: the process where senators vet and question nominees for the federal bench. These hearings matter because the judges chosen will be interpreting the Constitution and federal law for decades, shaping the rights, freedoms, and lives of millions of Americans, maybe even your own. Lifetime appointments are on the line, and lately, there's a lot of concern about whether we're getting qualified, unbiased public servants or just more foot soldiers for the political machine.
Mr. Chairman, I believe, am I the last senator to question?
No, Senator Welch.
Would you like me to defer to you, Senator? I am happy to. Yes, I'm also willing to defer to you. It is not, but it is a genuine offer. I will cede to you. Thank you, sir. Congratulations to each of you and to your families. I appreciate your willingness to step forward and serve. I have just a general question that I've been working on with one of my colleagues. The amount in controversy that creates diversity jurisdiction has been set since 1996. The amount that is at issue in most cases and the volume of cases has gone up dramatically. Could each of you just briefly tell me something about why you think we should or should not increase the amount in controversy required to create diversity jurisdiction, and why that would be an appropriate thing for this Congress to do or not? Briefly, Ms. Clark.
Senator Coons, as you pointed out, the amount in controversy and diversity jurisdiction is $75,000. And at this stage, that's a very low bar, especially when it comes to civil litigation, to allow a potential plaintiff or even a defendant to remove a case from state court into federal court. I have not thought thoroughly about what that number should be, but I do recognize that that is a low number.
Thank you, ma'am. Ms. Clark, Ms. Lane, forgive me.
Senator, I think that would go to kind of an ongoing debate about what's appropriate. And as a nominee, I wouldn't want to get too far out over my skis on that one. But I would just say that, as a federal judge sitting in diversity jurisdiction, I would follow the $75,000 threshold until Congress changes it.
Sir.
Thank you, Senator. My practice has been almost exclusively in criminal law, but I'm certainly aware of this low threshold that exists. I think, again, in terms of Congress increasing that threshold, I'm hesitant to kind of comment on potential legislation that this body might take up and support it or be against it. But I definitely understand the concern. This is not so much of an issue that we've seen in the District of the Virgin Islands, but I do understand it's a nationwide problem.
And does the elevation of cases from territorial court to federal district court have the same dynamics and impact on volume as it might in the other districts being represented?
I think I don't have metrics for the other districts. I think this is less of a problem in the District of the Virgin Islands, but it's an issue that's there, and it is something that's been debated in the bar. And again, I just think it would be I'd just be hesitant to comment on potential legislation as a nominee.
Ma'am, Ms. Westerkamp.
Senator, the Court of International Trade is a court of limited jurisdiction, and so it doesn't really apply.
So maybe I'll move on to questioning you about something directly in your bailiwick. Ms. Westerkamp, just if you'd briefly tell me what's your role been in advising President Trump on the tariffs that he issued under IEEPA, the International Emergency Economic Powers Act?
Senator, so consistent with past precedent for nominees who have appeared before this committee, who worked in the executive branch and cognizant of the various privileges that the executive branch enjoys, I can talk about specific matters, but not the advice given or to whom the advice was given.
So did you discuss with President Trump how CIT should or might rule on the legality of these tariffs?
Senator, that gets, again, into areas that I can't discuss, but I can tell you that I did work on various executive orders citing IEPA, and since the learning resources decision, I have not had further work related to that, and I'm also not working on any of the ongoing litigation that's currently back before the CIT.
Given that the Supreme Court ruled 6-3 against the administration's position and declared these tariffs illegal, have you discussed with the president your views on what should be done to refund $160 billion now that the Supreme Court has invalidated those tariffs?
Senator, again, that is a matter of active litigation before the CIT, and it's a matter of public debate, too, with different economists as to how to tackle that question. And so as a judicial nominee.
For you, you wrote in your Senate Judiciary questionnaire you would recuse in any case touching upon work you performed while in the counsel's office. Would that cover everything that relates to IEPA or tariffs?
Senator, pursuant to 28 U.S.C. 455, which is the statute governing recusal, I would take any recusal matter very seriously, discuss the matter with my colleagues, and determine whether recusal is appropriate. And I think with the various subject matter that I have worked on at White House counsel's office, I would very seriously consider whether recusal would be appropriate.
Your answer in the questionnaire was not as carefully cabined or constructed. It was you would recuse in any case touching upon work you performed in the counsel's office. Was that not accurate?
No, Senator, that is accurate.
Last, if I might, to Ms. Lane, I'm deeply concerned by the lack of legal experience you bring to a lifetime position. Senator Schiff probed a number of questions. My understanding is you graduated in 2017, have been out of law school about 9 years. Putting aside your 2 clerkships, how many years have you actually practiced law?
I've been very fortunate to have practiced law since graduating law school and after my clerkships, and I have worked on over 50 cases. I filed over 100 motions in federal and state courts at every level, and I currently manage a litigation docket of over 100 cases. I'm very grateful for the wealth of experience that I've had.
So you mentioned in your questionnaire that while at Consovoy McCarthy, you drafted outlines for direct and cross-examinations and cross-examined a witness. You only mentioned one cross-examination. You've certainly conducted more than one cross-examination in federal court. Is that correct?
I conducted that one cross-examination, Senator, but I've been very involved in the preparation of witnesses.
Conducted one cross-examination in federal court. Is that correct?
I have, Senator, and I have also worked extensively with preparing experts, helping prepare. I also took a deposition.
Questionnaire, you took a deposition of an expert witness. You've certainly taken more than one deposition in your legal career. Is that correct?
Senator, I've taken a deposition of an expert, but I've also been deeply engaged
deposition.
And
I've taken one deposition.
Yes, Senator, and I've also had the
You
opportunity.
said in response in your questionnaire that you've drafted outlines for direct examinations. How many direct examinations have you conducted?
Senator, I have, like I said, drafted outlines for direct examinations and helped prepare witnesses and second chair depositions.
Chairman is doing his best to draw my attention and get me to end. I'll simply comment in closing that you've been held in contempt for flagrant disregard of a court order. The legal team of which you are part, to be specific, I think the combination of your lack of experience and that weighs heavily against your nomination. Thank you for your indulgence, Mr. Chairman.
Let's get into what happened in this particular hearing. Senator Coons and others are questioning several judicial nominees. First, there's some back and forth over procedures and courtesy, which is standard. Then they turn to substance, and Coons brings up an issue every conservative needs to understand: diversity jurisdiction. That's the legal threshold that lets lawsuits be moved from state to federal courts, which has been set at $75,000 for nearly 30 years. Think about that. In 1996, $75,000 meant a lot more than it does today. Adjusted for inflation, that's barely half as much purchasing power. Meanwhile, lawsuit abuse in civil litigation has exploded. Personal injury lawyers, class actions, and activist groups have all used the federal courts to pursue political goals and jackpot justice. The result? An overloaded court system clogged with cases that arguably don't even belong in a federal courtroom in the first place. Senator Coons asked the nominees if that threshold should go up. What do we get in response? Hesitation, evasion. Not one nominee is willing to give a straight answer about whether raising that limit might be a good idea. Clark admits $75,000 is a low number but doesn't commit to anything. Lane doesn't want to opine. Another nominee says it's not seen as an issue in the Virgin Islands, and one says it's not relevant for the Court of International Trade. If you're watching this as an American taxpayer, or even as someone being sued, this should infuriate you. The people hoping to be confirmed to the federal bench won't even take a stand on whether the courts they may serve on are being jammed up by unnecessary cases. If they can't be candid about basic policy, how can we trust their judgment when they have real power? This is classic inside the Beltway cowardice. And it's a huge reason why so many Americans have lost faith in the impartiality and courage of our judiciary. But it gets even worse. Next, Senator Coons turns to tariffs and the use of so-called emergency powers by the executive branch. He asks Westerkamp about President Trump's use of IEPA, the International Emergency Economic Powers Act, to issue tariffs. Now, as patriots, we've seen firsthand how tariffs can be necessary to protect American workers, secure our borders, and stop hostile nations like China from steamrolling our economy. It's perfectly legal and often vital to use these tools to preserve our sovereignty. But rather than explain why Trump's actions were justified, or even acknowledge the legitimate debate, what do we get? Dodging. Legalese. I can't discuss advice or privilege. That's ongoing litigation. I'd have to recuse myself. In sum, no transparency, no courage, and no clear defense of putting America first. Let's be clear, this playbook is deliberate. The left-wing elites that dominate Washington want to pretend judges are just neutral umpires. But in reality, the bench is being stacked with people who refuse to show any backbone or commitment to America's core interests. If the right nominee ever said, yes, raising the threshold would help prevent suit abuse and protect the federal courts, or even America needs tariffs to protect our jobs, you know the establishment would come down on them. This is why they all talk in circles, never tipping their hand until it's too late for us to do anything about it. But the worst part comes when Senator Coons questions Mississippi Lane, one of the nominees, about her legal experience or lack thereof. Apparently, she's been out of law school for less than a decade, with precious little trial experience. When asked directly how many depositions and cross-examinations she's done in federal court, the answer is basically one. One cross-exam, one deposition. This is for a lifetime appointment that will decide the fate of businesses, families, even state laws, someone with just one deposition on their own, sitting as a judge for life. How is this possible? Well, it's possible because in this new era, it's not your record, skill, or earned respect that gets you nominated. It's connections, loyalty to the progressive agenda, and willingness to rule with the left whenever they need it. The Democrat machine will bend every rule, push every lightweight, and ignore every red flag if it helps cement their control of the courts. The kicker is that Lane's legal team was even held in contempt. Yes, held in contempt of court for flagrant disregard for a court order, and yet Democrats still see fit to put her up for a lifelong judgeship. Experience doesn't matter. Accountability doesn't matter. What matters is raw power. Let me spell out why all of this affects your freedom. Federal judges decide the Second Amendment cases that determine whether you could defend your family or not. Federal judges decide free speech cases, whether you can express your viewpoint in public or online. Federal judges make the calls on religious liberty, government overreach, and so much more. And now we have hearings filled with nominees who refuse to take stands, admit their inexperience, and seem more loyal to political handlers than to the Constitution. This is why elections matter. This is why we fight. We need judges with experience, courage, and respect for the plain words of our founding documents, not empty suits and activists in black robes. I urge every senator, stop rubber stamping these weak nominees. Hold the line for America's future. If you agree, make your voice heard. Share this video. Leave your comments below. Do you think this is the way the judicial branch should function? Should people with so little courtroom experience be handed a gavel for life? If you want real change and representation for the American people, join us. We're not giving up this fight. Thanks for tuning into Freedom Forge. Don't forget to like, subscribe, and stay informed. This is your country. Don't let them take it from you. Fight for liberty, fight for truth, and never back down. See you on the next video.